Hi, my name is Ed Sullivan. I am the lobbyist for the Illinois State Rifle Association. So we finally got out of session, and I just wanted to give you a little update on what took place this last year from January to May. A little recap, if you will. So what we know is the last 2 years, there's been 185 bills, gun bills, that have been introduced in the General Assembly. There is probably 60% of those have been anti-Second Amendment bills that we've been tracking, plus amendments, so quite a bit of work to look at. This session from January to May started out pretty slow. As we all know, there was a election in March, the primary election, and so the majority party decided not to do a lot. There was no gun bills introduced for a hearing during that time, but things picked up at the end of May. The last 2-3 weeks of May, we saw a lot of activity, a lot of discussions on some bills, and I'm gonna talk a little bit about those now. So one of them was what's called the Cook County Forest Preserve Bill. It has to do with concealed carry, House Bill 3791. So there was a gentleman by the name of Mr. Solomon who was arrested about 4 years ago, in Cook County Forest Preserve. He was fishes all the time, concealed carry holder, legal. He was approached by law enforcement in a forest preserve after dark, after he was fishing, and he said to them freely that I have a firearm on me. He was subsequently arrested. What we know is in the Concealed Carry Act, Cook County Forest Preserve, exclusively, the entirety is a non-carrying prohibited place. So he sued and won. The courts ordered the General Assembly to come up with change in the law. They never did, and so as far as I'm concerned, Cook County Forest Preserve is now like all other 101 counties that you can carry in. Anyways, they did file a bill. In essence, what we're talking about is sensitive places. They tried to declare the entirety of the Cook County Forest Preserve sensitive places by identifying individual places that they wanted to have concealed carry illegal. But the biggest problem with this is two things. One, they decided to allow any county to be able to enact this ordinance, this law, if they wanted. And so, one of the things that when we did the Concealed Carry Act, we got state preemption, meaning the state law overrules all local laws. And so this is the first crack to preemption, and so that's something that we certainly would never want. They also said that within 70 feet of whatever prohibited place that they wanted to say was also not eligible for concealed carry. So in essence, you could have a Cook County Forest Preserve and you could have a home within 70 feet of the Forest Preserve, and that would be declared a prohibited place to carry. So we fought that. It never got a hearing, and so we'll keep monitoring that. A second bill was lost and stolen firearms, House Bill 5595. So what this says is instead of 72 hours, you must report your lost and stolen firearm within 48 hours. Except there's some ambiguity on how you would report that or how you would know when it was lost and stolen. I have a safe that I might not check for 3 or 4 months. Maybe we left it open and one of my kids' friends took something. Lots of different ways that you can get afoul of the law. The issue here is for an administrative error by not reporting, and also it would be declared a misdemeanor, you could lose your FOID card. There is a court case out there, Rahimi versus the United States. It's at the U.S. Supreme Court. We're expecting a ruling any day now, within the next, by the end of June. This is going to level set whether someone could lose their Second Amendment rights based on a misdemeanor. Should it be felony level or more? I'm going to talk about that in a minute, but that is one of the reasons why we said that maybe they should not act on that. So there's another bill, there's 2 more bills, but one of them was called Katrinas Law. And so it's gotten a lot of press over the last year, and we've been kind of talking to the other side in regard to this. It has to do with the gentleman that murdered his wife and daughter, a domestic violence situation. Obviously, people that are dangerous probably should we should take a look at whether they should have Second Amendment rights at that point. But once again, this is one where we want to see what the courts are going to have to say. In this case, the state failed Katrina Gonzalez. Absolutely failed her. She did everything correct. She filed a restraining order, domestic violence restraining order. The state never went in to talk to Mr. Gonzalez. At one point, Mr. Gonzalez came back to the home and the police were called. The police filed a clear and present danger report against this individual. And a week later, he ended the life of his wife and daughter. And so obviously sensitive issue and one that we're going to keep an eye on. But once again, we don't think anything should take place till this Rahimi versus United States takes place. So the last bill that I want to talk about is safe storage of firearms. It's Senate Bill 3527, Amendment number 4. This is the only bill that actually got traction, that was listed for a hearing in committee. They never heard it, and I'll get into why. But this is a bill that we're going to keep an eye on, because they potentially might want to look at this in the fall veto session, which will be the second and third week in November. But this bill basically says a person, if you reasonably knew a person was 18 or under, so they changed from 14, but 18 or under, if you reasonably knew they might have access to your firearms, you need to have things in a safe storage. So a couple things that are problematic with this bill, aside from the fact that a soldier could go off to war and get permission below 18, but why would they want to think about that? But a few things that are problematic with this bill. First, they also describe who are prohibited to, or a prohibited person is one of the folks that potentially you could have problems with in your home. So the actual language says a prohibited person, anyone not able to possess a firearm under state law. So think about that for a second. Who is a prohibited person that is not eligible to possess a firearm under state law? Anybody that doesn't have a FOID card. And so the expansion of prohibited people within your home was exponential. And so that obviously is a non-starter for us. They also make it a civil liability. And so now you could have someone come into your home, steal your firearm, kill somebody, and then that person that was killed's family could sue you. And so another huge issue that we've been kind of tracking. And lastly, they now define your places of residence to include your home, your work, or any place under your possession, immediate possession. And so you would, in essence, have to have a safe storage for your home, your work, your motorcycle, your car. And so obviously buying multiple safes potentially is in essence going to go against recent court cases, specifically Bruin, that says excessive fees could be grounds for denial of a law. And so that leads us to the court cases and why we didn't see any bills come through this session. So Rahimi versus United States, an individual from Texas, not a really good individual. He was charged with domestic violence, and he then took his case all the way to the Supreme Court based on Bruin and said, should someone lose their Second Amendment rights based on a misdemeanor versus a felony? And so what we saw was the Solicitor General, under questioning oral arguments at the U.S. Supreme Court, was asked, what should be the level? And at that point, the Solicitor General in the Rahimi case during oral arguments said it should be felony level or above. And so that's kind of a big case for Illinois law, and specifically on the FOID card, because there's so many instances where you could lose your FOID card, therefore your Second Amendment rights, based only on a misdemeanor. And so we've been waiting for that, and we've been saying for better part of a year, and especially with this Katrinas Law, that maybe we should slow down, wait for this probably precedent-setting, well, we hope precedent-setting case at the U.S. Supreme Court to be heard. And like I said, that should be in the next few weeks. But ironically, the last week of session, there was a court case at the Illinois Supreme Court that was argued by the Illinois Attorney General's office, and that court case was Davis versus Yanchenko. Mr. Yanchenko was the Firearms Services Bureau chief. The Davis brothers were having a celebration, and they shot their guns off at night. Not real smart, but here you have it. They lost their FOID rights based on a charge, not a conviction. And so they sued. That case is before the the Illinois Supreme Court. But the irony here is this. Illinois State Rifle Association has been saying, let's wait for Rahimi to be finalized to give guidance based on certain laws. And so the Illinois Attorney General's office argued the exact same thing before the Illinois Supreme Court. They said that maybe they should not rule until the Rahimi case is done to give them guidance. Well, the government affairs team in Springfield decided that we would explain that to, or point that out to the Attorney General's office and the Senate Chief of Staff, and maybe they should pause and not move forward with these laws. And remarkably, they did. So that's good. It was a big win for us. But once again, we'll be vigilant, and we'll see what Rahimi has to say. We did have one big win, House Bill 4500. So as you know, if you have an expired FOID card, you could get charged with unlawful use of a weapon, UUW statutes. So there was a discussion to change the wording, not necessarily the charge, but the wording from unlawful use of a weapon to unlawful possession of a weapon. Illinois State Rifle Association supported that change because if you think about it, what we know is there's no longer an expiration date on your FOID cards or your concealed carry licenses. And so do we want to trust that Illinois State Police are going to notify us on time that we need to go renew our FOID card or CCLs? I don't want to take that chance. And so at the very least, the terminology change is a little better way of wording things because it's really more about possession versus use. Whereas you go to you go in for a job interview or you're trying to rent a property and they pull up your file and it says, well, you're charged with illegal use of a weapon. We'd rather it say possession. And so that was a small win, but needless to say, it was a win. So we like to see that. But we know that November's coming fast, and we will keep an eye on all the things that are taking place that I just described. I do want to give a shout out to my good friend Todd Vandermine, who is the owner and runs the YouTube channel Freedom Steel. He's done a really good job taking care of watching court cases, not only in Illinois, but across the nation. He's really a great friend to the Second Amendment, and it was a lot of fun to bounce off some ideas on what was taking place in Springfield to him. So I just wanted to, I'd be remiss without giving him a shout out for all the help he gave us, especially on these court cases. So with that, Sullivan out. Everybody, have a good day.